And the former speaker has cited the state of South Africa's prisons as part of the reasons why she should be granted bail. Legal analyst Ian Allis now joins us to look at this and some of the other reasons that Nosiviwe Mapisa-Nqakula cited in her bail bid, and joins us now. Ian, good morning. Thanks as always for your time. Perhaps we can start with a little bit of housekeeping as to why Mapisa-Nqakula's defense team went to the length that they did to detail her bail application bid and the reasons for it, even though the state would not oppose bail. It seems that the court is not obliged to accept the state's acceptance of an accused, bid to get bail.
Good morning, Iman, and good morning to the viewers as well. The starting off point is because it was a Schedule 5 offence, corruption and money laundering falls into a higher level. So irrespective of the state opposing bail or not, the onus is on, or the duty to prove the need for bail in the interest of justice is on the accused in a schedule like this, because it's such a high level of a crime. So that's the reason why. So even if the state doesn't necessarily oppose bail, it's still up for the accused to go to show good grounds why they should be given bail. It's basically, bail is a privilege, not a right. So that's why if it was a lower offence, say shoplifting, then it would be something where you could just, by giving an indication of a fixed address and fixed employment, and that there's nothing very onerous. But because of the charges, that's what necessitated it.
So let's then go to some of the issues that she raised in her bid for bail. And this was really detailed by her defense team yesterday. And I think I want to foreground it by saying that a lot of what's been happening in this particular case has been questioned around, the idea of preferential treatment and whether she, because of her status in society, is being treated a little more deferentially, or quite, deferentially than an ordinary person might be treated in terms of their arrest and making arrangements around how they would hand themselves over and so on. So this issue of her citing conditions in the country's prisons, she was saying it's overcrowded, potential for assault if she was there and detained there until the trial commences. There'd be significant threat to her safety and security because, of course, she's an older woman and so on. Just talk to us about that. And in fact, before you answer, I just want to quickly play a portion of an interview that we had with the Defence Minister a little bit earlier on the issue of South Africa's jails and prisons, and we'll come back for your response. All right, we'll try and play that for you, this portion of an interview that we did with the Correctional Services Minister a little bit earlier on, talking about the state of the country's prisons.
The state of our prisons, we run them in line with the Nelson Mandela rules that are universally accepted and by the United Nations. So that is the state of our prison. And as you are aware, there is also an inspectorate that is responsible for our prisons across the country. So that is how we handle them. And from time to time, we deal with complaints and we have got mechanisms to resolve them.
Maybe just share with us, Ian, your thoughts on that particular portion of her bail bid.
Let me put it to you this way. It's basically, there's two words that I can use, ironic and hypocritical. Is realistically, jail is a horrible place wherever one wants to look at it. Some countries are worse, some countries are better, but as far as it goes, that is not a basis to be allowed bail. And the problem is there was such emphasis on it and in her health conditions. It does smack of preferential treatment. Not so much in just the handover, because there are elements where one can go ahead and hand themselves over in a slightly more amicable manner. But to use that as a basis when you coming from the position that she does as the national speaker and former minister, that's quite hypocritical to say, well, our conditions are too deplorable for her to be detained in. So the factor is, that are they bad? Yes, they are. Are jails worldwide bad? Yes, they actually are. That is not a basis. And yes, it does smack of preferential. It would smack of preferential treatment and hypocrisy with the argument. The argument with regards to a bail application for this is the interest of justice, not the interest of the individual. And there are many people in jail who have the identical same conditions as she does, and even worse. So I'm going to say that it's becoming more of a ploy of what people are using in extradition and bail applications, but it's not. It's not a testing factor, and it shouldn't really come into effect of the conditions of our prisons.
Ian, and thanks for that. So it's going to lead to the obvious follow-up question. For other people who will be going to court and wanting to apply bail, can they use what's happened in court yesterday in the Pretoria Magistrates Court as an example to bolster their bid to stay out of jail and get bail?
Honestly, and after doing numerous bail applications myself, no, you can use it, but it's not going to go ahead and work. Perhaps in the aspect where it's a non-violent matter that you gain, there might be certain emphasis on the fact that it's a non-violent crime. But those grounds are not going to go ahead and fly for your normal person. I think they're over-exaggerated. And in the end of the day, and the fact is, they don't hold water for a bail application of this nature. You can't say a person can't go into jail because it's a horrible place to be. What next? Is she going to say she shouldn't be, if she's convicted, should she not be be forced to go to jail because it's a terrible place, they might attack her? It's illogical.
I want to go to one final thing before I let you go, Ian Allis. And, we always say that when we shine a spotlight on the country's courts, it allows the everyman to see the workings of courts and to basically sort of raise their own intelligence when it comes to how these processes work. There was an interesting thing yesterday as well that she raised, that she hadn't fully consulted with the legal representatives. I have, after having attended a couple of many court cases actually, seen this as as an argument that predicates a bail application. Because one of the reasons that she raised was that she still has not had disclosure. She doesn't know what the case against her is, except for the media reports that she has seen and some of the leaks and so on. And in her view, this could only have come from the NPA. What are the obligations, from either the state or others to provide the basis upon which you're being arrested and that disclosure on what we have that's going to take you to prison?
Disclosure for court purposes is only given after the investigations have been completed and when the matter is going to be proceeding further to trial. Is in a situation for bail, all you need to do is have a face value of a charge of what you're in actual fact facing. The fact that she knows that it's fraud and money laundering, that is sufficient in order to ensure that the state has got a case. It's, for example, this is where fraud and money laundering are genuine cases on the Criminal Procedure Act schedule. It's not as if she's being charged with painting offence red, where there's no such charge. Then there's no such charge. But on the face of it, there is a charge. So that's what she has to go ahead and meet, and that's what she has to show. It's in the interest of justice that she doesn't sit in jail pending trial, as opposed to actually not be granted bail and having to sit for that period of time. So realistically, that is going to be the scenario. She's not entitled to the disclosure until the investigations are fully complete, and then she'll be proceeding to trial. So it's too premature for her argument.
Ian Allis, as always, thank you for your time. We appreciate it. Just some perspective you're welcome. Just some perspective there on the bail application that we heard yesterday in the Pretoria Magistrates Court involving the former Speaker, Nosiviwe Mapisa-Nqakula.